Coming up next is the Dr. Kim Taylor Show. Here's your chance to talk about what matters to you. Although you'll receive helpful advice from Dr. Kim, remember this is not to be construed as any form of psychotherapy, diagnosis or treatment, and cannot replace a therapeutic relationship with a mental health professional. You can reach Dr. Kim by calling 564-1290 or 866-564-1290. You can also listen live on the internet at drkimtaylorshow.com. Now, here's Dr. Kim.
As a psychologist in private practice for over 20 years now, I've certainly worked with a number of couples who've been at various stages in their relationship. Some who come to work to improve their marriage, and then there's others who come to fix a broken marriage, and then still others who are coming to end a marriage. And I often get asked, can a marriage be saved with therapy? And my answer is always, if you go to the right therapist, absolutely. But herein lies the catch. You want to go to a therapist who will hold each person accountable for their own actions. What I always tell the couple is that it takes two people to make a relationship, and each person has to start taking responsibility for their own part of that relationship. Because too often what happens is couples get into the habit of blaming or complaining about their partner. And they do what I call taking the other person's inventory. And then they start to form what changes their partner should or should not make, with very little time spent on looking at themselves and asking, what am I doing here that is either helping my relationship or hurting my relationship? The truth is that no relationship can stay the same, even if one partner is willing to change and take a new and different step. So the first step of couples work is to help the individuals to stop pointing the finger at their partner and to turn the focus back on themselves, and then to learn how to come from their highest self when trying to deal with the differences and the problems between them. If I can get the couple to focus on changing themselves, then I have a formula to make positive changes in that relationship. Remember, in a relationship, you have far more control over being able to change yourself than trying to change someone else. Now, having said all that, there are going to be times when a relationship is over and the marriage is headed for divorce court. And whatever happens here, you have to keep in mind is that the same principles should apply, and each person really needs to look at their own behavior and do what will make them proud of themselves at the end of the day. It is so easy during this time to act out on a very impulsive way or a very emotional way and just be reactive. But when we hold ourselves to a higher standard, and we really act in that way that's going to make us proud of who we are and how we showed up, then at least we can feel good about who we are, and we no longer need to feel that we're the victim of someone else's bad behavior. So with all of this in mind, what we are going to do today is we're going to talk about what happens when a marriage is headed to divorce court. There is no one way to divorce, and no matter how you slice it, divorce will always take a toll on the parties involved. Just that emotional upheaval alone that comes during this time can make it very difficult to navigate your way through the legal process, and it may even impair your ability to make good decisions for yourself at this time. So today my guests are Superior Court Judge George Eskin and family law attorney and mediation expert Penny Matheson. And they're here to discuss the process of divorce and what you should know before beginning this process. And it's really important to know that there are a lot of steps that you can prepare yourself for prior to even starting out. So if you have a question, get on the phone now and give me a call at 805-564-1290 or toll free at 866-564-1290. You can also send me an email with your question at drkim@drkimtaylorshow.com, and we'll try to answer your questions on air. So let's not forget that I'm here for you, and you only have to pick up the phone and give me a call. I'd love to hear from you. I am Dr. Kim Taylor, and I'll be right back after these messages with my guests.
You are listening to Dr. Kim Taylor on KZSB AM 1290.
My guests are retired Judge George Eskin and family law attorney and mediator Penny Matheson. And we're talking about what happens when you decide to get a divorce and what to expect in both the court system and or through a mediation process. So welcome to the program.
Thank you. Good afternoon, Dr. Kim.
Let's start out by talking about the process of mediation. Penny, could you really explain that? What is it? Because most people think that they just go through the court system, and that's the way that they process a divorce. But in fact, there are many other ways to resolve some of these conflicts. So could you introduce us to what mediation really is?
Well, if you decide to mediate and get referrals for the mediators that you would like to interview, you will be sitting at the same table with the mediator, preferably at the same table at the same time. And from the beginning of the process, you will be going through all of the gathering of information together with the mediator that is necessary to address the issues. And I think it's important that this mediator be a family law attorney, because you will be drawing on the family law code and identifying issues and making decisions pursuant to the law. And it's a good resource to be working with a family law attorney to accomplish that. This process will take you from the beginning of the negotiations through the issues of property division, spousal support if it's relevant, child support if there are minors, a parenting plan and custody decisions if there are minor children. And in mediation, there's a little more flexibility. You can go beyond what some of the court issues that the court can address with older children, college-age children, planning for that part of your future. And the end result is a marital settlement agreement, which is filed with the court. And if the mediation is successful, there's not a need to make any appearances before the court. The paperwork is filed with the court, and the order of dissolution is entered by the court. During this process, you also may decide to have independent counsel to refer to. And either party is welcome to pull in their lawyer at any time in the mediation process.
So why would one use a mediator as opposed to a lawyer?
Well, you have the privacy, first of all. I think the intention is to minimize trauma and keep the emotional toll, although it's almost impossible to eliminate it, but to try to be in a place where you might feel a little safer to express your fears and your goals and, you know, what it is that you want to accomplish and what needs to be addressed within the mediation.
Is it really very important to have your own individual counsel also while you're going through a mediation process, or can it be done without? And if you need one, why would you need one if you have a mediator?
Well, sometimes the issues become complex and people are afraid that they're not making the right decisions, and so getting a second opinion from a lawyer who can look at it through their eyes and analyze it from their perspective can be very reassuring, and quite frankly, it's often very helpful to the mediation process. It gives people more confidence about the agreements that they're entering into.
And would that lawyer be a part of the process, meaning that would they be in the room or just someone that they would refer to if they had a question and things weren't going well and they had a question about what was coming up and what they should settle for?
That is really up to the mediation clients. So the spouses, they can decide. Sometimes it's a little too intimidating for one to have one lawyer there. So if that happens, usually the other person feels that they need to have their lawyer there. And then it also depends on what the issues are. If they're very complex and they feel like they may have questions that they need to address to their lawyer on the spot. So sometimes there are 5 of us at the table working together.
Okay, and you had also said that sometimes you can all work in the same room, but sometimes it's going to be that one lawyer and one person is in one room, one lawyer, and the other person is in the other, and you're going back and forth between them, correct?
Some people are more comfortable being in separate rooms.
Okay.
It wasn't my style, but I felt that it stayed a little more authentic if both people were in the rooms and they got to hear everything, so that they had more trust in the transparency of the mediation.
But of course there's going to be those cases in which there might have been abuse or things like that where they just should not be in the same room, and it's better to keep
then
them separated
safety becomes an issue,
Okay.
and whatever allows them to feel safe and comfortable so that the process can go forward.
Okay, so from your point of view, what makes a good mediator? What is your role in that room as far as you're seeing?
Well, a mediator is facilitating getting the story out from both parties and beginning to see the common ground and the common threads upon which an agreement can hang. And that it's complicated because you are looking at a community estate, all of the property, all of the financials, any kind of debt. So it's the disclosing part of it is so key, and allowing each person to say everything that they need to say, regardless of what the patterns of communication were during the marriage. This is a different structure. You want both parties to be able to have the freedom and the safety to talk about whatever it is that will lead to resolution.
So you have to be pretty good at setting the boundaries and creating a framework in which, number one, they feel safe, but also that they're going to be, that they need to tell the truth, that it is an open process, that each person gets to be heard, and that needs to take, it sounds like a very strong person to be able to do that, especially in a very conflictual situation.
It's there are some difficult situations. yes.
That was a code for it's got to be a tough business.
The level of civility, is so key. And I've found that it's been so helpful when the parties have had work prior to the mediation with mental health professionals, as far as any kind of issues that they may have had together or even separately, and finding their the ability to communicate what's really on their mind and be honest about that.
Well, and I think that if they go through that process, one thing that they definitely should learn is that this is not going to be the time that they're finally going to get to change their partner, which is what they've been trying to do the whole time, which is probably why they are ending up in divorce.
We take them as they come.
Okay.
There will be no changes.
All right. So, Judge George Eskin, I'd like you to kind of be involved in this. And really, from your point of view, when people are faced with a dispute, do you recommend a mediation process rather than filing a complaint within the court?
Ordinarily, yes. I think mediation is the way to go in resolving disputes. And I think the court system would support more people using a mediation process to resolve their differences, just generally speaking, than going through the gladiator versus gladiator combat forum that the courts are used for. I do think it's important, if we can come back to the conversation that you were having with Penny, to step back and look at the big picture with regard to what you're describing as divorce, because that term no longer applies in California. And for the past 50 years in California, there's been a trend in the law to try to reduce the adversarial nature of what we now call dissolution proceedings. And the proceeding is really the dissolution of a legal relationship that was established when the marriage occurred. And when the marriage occurred, certain legal obligations and expectations and anticipations were created that the parties may not be aware of. And so a point in time comes when you described it as a person decides they want to get a divorce, and I hope they would have first done what Penny suggested and spent some time in counseling and therapy and trying to work out the differences, work out whatever issues that have led to the apparent dissolution of the relationship. But the whole process is supposed to be geared to getting away from, as much as possible, the acrimony and trying to persuade people to understand that whether or not the marriage relationship is terminated, when it is terminated, there are going to be ongoing relationships, ongoing contacts, especially when there are children involved, that they should be thinking about, and not simply the disputes that they're having over other matters right now. And so I think, generally speaking, that we are coming to realize that mediation can be a much more effective process for all of the parties involved, that they have a level of control over the outcome that they don't have when they present their cases respectively to the court, and the judge, makes a decision which may not please either side. Through the mediation process, you're able to hammer out an understanding and agreement for going forward and resolving the disputes that is less hostile, less acrimonious, less confrontational, and I think produces a better result for all.
Do you know, most people, I think, are surprised to find that going to court will not always provide a fair outcome. What are these, how do you decide, or how in the state do you decide? Is it just you add it all up and split it in half? Is it as simple as that?
Well, now you're talking about the property, I assume, and not the children. Well, I think it's really important to understand that there's a whole body of law, of statutes and court decisions that have been rendered based upon the law and based upon various circumstances that have come to court in the past. And the judge is bound by the evidence that is presented, that is the facts, the testimony, the documents, the expert witnesses who are called to testify about various aspects of the issues, and the law that has been established either by the legislature in statutes or by prior court decisions. And the judge is limited to applying the law to the facts that are presented to him or to her in the court proceeding. And that decision may not at all please either party. I really think that for a person to go into court bent on winning, especially in a family law situation, they're going to be extremely disappointed. I think frequently in the court process, unless there is an agreement, unless things are worked out, there are no winners.
Okay. So if we just switch back for a moment to if they go into mediation, they have to disclose the truth, and they have to, put up reports and talk about expenses and debts and assets and things like that. Are the decisions that you come up with in mediation binding? Because I think that's one of the questions that people have. How do they tell the truth, and how do you make sure they tell the truth, and how do you make sure that they hold to it and that it's enforced?
Well, within the mediation process, just as if you were represented by counsel, independent counsel, you're required to disclose pursuant to the family code. So you have disclosures of all of the assets and the debts and the financial information. And it's key to be able to put the pieces of the puzzle together. That disclosure is signed under penalty of perjury. If there is false disclosure, there are remedies under the family code, although it takes a lot of time and a lot of money in order to get that done. But I do have to stress, it is done under penalty of perjury, and we take it very seriously. Also, if we base an agreement on what has been disclosed, and we also make the decisions about what experts we need as far as additional information, evaluations, appraisals, tax information, all of that is based on what their disclosure has put on the table. So then we move towards the decisions that they make, and that becomes the order. Those decisions are part of the marital settlement agreement, which is then signed, and it becomes an enforceable court order. Mm-hmm. So when you say, are they binding? Now, a mediation may take a long time. It may take a year and a half to get through all of this process, and they may change their decisions because they think it over, they talk further, and they decide that some other arrangement may make more sense. So there's that opportunity to change your mind. Mm-hmm. But once it's in this marital settlement agreement and it's walked over to the court, it's binding.
Okay.
Well, Dr. Kim?
Yes.
Are we running out of time at this point?
No, go ahead.
Okay. I think two important things that Penny just mentioned need emphasizing. First, the decisions they make, they referring to the parties, right. They referring in the family law situation to the husband and the wife, not a decision made by the mediator. The mediator does not make decisions. The mediator helps the parties come to joint decisions. Mm-hmm. And this process is not separate and apart from the court. It's part of the court system. And a petition is filed for a petition for dissolution of the marriage relationship, and the documents settling the issues that are raised by a petition for dissolution are placed in a document that are submitted to the court for the court to enter judgment on that agreement. And that's how it's enforced. The provisions of the judgment are enforced.
Okay, great point. We need to take a quick break, and I'll be right back with retired Judge George Eskin and mediator Penny Matheson.
You are listening to Dr. Kim Taylor on KZSB AM 1290.
If you are just joining me, I'm here with Judge George Eskin and mediator Penny Matheson, and we're talking about the importance of understanding the process of divorce and what to expect either in the court system or through the mediation process. So, Judge Eskin, what are some of the hazards of hiring a very aggressive lawyer and going through the court system?
Well, I think the first thing is something that Penny mentioned, and that's a loss of privacy. The document that's filed with the court initiates a process that is open to the public. Every time the case is called in a courtroom, the public has a right to be there. The public has a right to inspect the documents that have been filed, the allegations that have been made, although in the form petitions that are filed to initiate a dissolution action, there isn't much room for alleging fault by one party or the other, this being what we call a no-fault state. But thereafter, in the discovery process and the law in motion process, declarations can be filed and allegations can be made that become a matter of public knowledge that could be extremely embarrassing. Depositions can be scheduled, and although depositions are not open to the public, it could be a very unpleasant confrontational experience. Certain costs associated with the fees charged by attorneys for the time they spend in court can get excessive from the standpoint of the client. The embarrassment of appearing in court and having these matters discussed is one of the downsides of going to court. The adversarial nature of the proceeding in court, despite the fact it's in re the petition of so-and-so for the dissolution of the relationship, with a very aggressive attorney can get extremely uncomfortable. And as I stated earlier, you lose control of the outcome and recognizing that you're going to have an ongoing relationship in many, many cases with this person. It's a combative environment that leads to further acrimony in the relationship and with other people. So there are many aspects to going to war approach in a public courtroom that are going to have financial and emotional costs.
I think one of the questions that I get is, does the person who hires the most aggressive lawyer have a better chance of quote unquote winning in court?
Well, as I said before, I don't think there are wins and losses in court, especially in family law cases. And I don't think winning is a realistic objective of a proceeding to dissolve that relationship. I think that it may be that the relationship is such that it can't avoid the acrimony and the combative nature of some attorneys. I don't mean to suggest that all attorneys are that way, certainly not. But there are those who take a very aggressive approach and create a lot of discomfort for everyone associated with the case.
I have a question because I have an email here, and they are talking about that they feel that within their marriage they've been very submissive, where the husband has been more aggressive. They're worried about going through the mediation process, feeling and thinking that, my voice is still not going to be heard, and is this the process for me, or is this the time that feeling like I need a bulldog, a gladiator behind me in order to feel like I get a fair share in this process? What do you say to that? Does mediation still work in this process and with this kind of issue?
Well, I believe it does, but the person that feels that way needs to find a mediator with whom they feel safe and able to present their side without having submission involved. So there has to be a balance of power that's maintained in the mediation. The patterns of communication, and I think I mentioned this before, during the marriage will be changing if one chooses to make those changes. It may be wise to first speak with a mental health professional to see if that person can trust a mediation setting. If not, they should probably listen to their instinct and talk with independent counsel and work with their own lawyer, possibly.
Penny, perhaps it would be helpful if you describe some of the techniques that mediators can use when they are confronted with a situation where there is such an imbalance of power and one spouse is taking over and dominating the conversation. What should a competent mediator do under those circumstances? Well,
there's structure within a mediation, and there is civility within a mediation. So each person is allowed to say what it is that is important to them. They are heard. It hits the record. It's considered. And the other person must allow that to happen if they want to participate in this particular process. If not, it's a waste of time, and we're going to get to an agreement that essentially is unenforceable if it were to be looked at by the court, or if enforcement were ever required and it was discovered that one party essentially didn't participate. It's just not acceptable.
So without taking sides, a mediator can remain impartial but also enforce the rules of the structure.
There are rules of the structure that allows both parties to have their say in a safe environment that is not abusive in any way.
So I'd like to get your point of view from both of you. Who makes a good candidate for mediation? Is there such a profile versus court and going to court and doing the litigation?
Well, I would think the number one quality would be a good listener, a person who is open to listening and knows the questions to ask to obtain the factual information that is necessary to help the two sides reach an agreement. So an excellent listener, one who shows compassion, one who can relate to the dispute that's presented before him or her. And I think there are also situations that come up where the mediator might suggest to the parties that there's some legal aspects that apply to your situation that probably should be referred to an attorney for legal advice as to how to proceed with regard to this particular dispute. So it's mediation and being represented by another lawyer are not mutually exclusive.
Mm-hmm.
I agree. I think that there are, and that is a part of an effective mediation, is recognizing when a person should be advised to seek independent counsel. You're still staying within the mediation process, but just to have your counsel available to you to fall back on and check in with.
And a third quality, that reminds me, Dr. Kim, a third quality would be an attorney who knows the family law, an attorney who is experienced in handling family law matters, either a certified specialist in family law. It provides an excellent background for a person who has the personal qualities, the personality qualities to do mediation to rely on, because knowledge of the family law is extremely important in advising the parties with regard to the potential consequences of whatever decision they may make with regard to property division or custody or support.
And what kinds of qualifications does a mediator have? Do they have to go through school and get licensed? Is there?
Well, I think first of all, it's important that it's a family law attorney, so they have those credentials.
So it's not just someone who's gone through just a weekend course.
Exactly. And then I think that there is, I don't know if you would call it a character set or a type of person that the personality lends itself to mediation, so that you can work within that process. I think understanding mediation and realizing that the mediator is not making the decisions.
Mm-hmm.
So it has to be a very, that ego that forces you to want to have control over how that agreement's going to look, regardless of what the parties are choosing. You have to step back and allow some things to happen. Mm-hmm. We talk about people hiding things in their disclosure. I've also seen extreme generosity that gives more than the law requires. Mm-hmm. So, it can go both ways.
Okay, we do need to take a quick break, but we'll be right back with my guests, Judge George Eskin and mediator Penny Matheson.
You are listening to Dr. Kim Taylor on KZSB AM 1290.
My guests for the hour are Judge George Eskin and Penny Matheson. And we are talking about the needs and concerns for spouses and family members who are going through a process of disillusionment. Is that what we're calling it instead of divorce?
Dissolution.
Dissolution.
But I have to say that most of my clients said disillusionment.
Okay. Well, then I don't
so
have
you're
it so wrong.
And they probably were.
And they probably. So the The place I'd like to start in right now is to really talk about how would you find a good mediator and how would you find a good lawyer? What are the qualifications that you should be looking for, or perhaps the questions that you need to be able to ask and prepare for before entering into that process? Penny, why don't you go ahead?
Well, it's a very good question, and it's a hard question to answer. I would go about it asking my friends, first of all. I would go to the people in my community that I trusted. So I would ask my friends. I would ask any lawyers that I knew. If I have someone that's done my estate planning, I would call that lawyer and say, who's doing divorces that you can recommend? Hairdressers are really one of the best sources of information that one can find. They hear so many stories and know about so many people in the community.
Perhaps too much.
Perhaps too much.
Well, enough, though, to say that I've had clients who had terrible experiences with so-and-so, and I've had clients who've had wonderful experiences with so-and-so. Mm-hmm. So, I mean, that kind of information is part of where you start with friends or acquaintances, other members of the PTA, other clubs that you belong to. Everybody knows someone who has gone through what we'll call the divorce process. What was the experience like? How did you go about it? What would you do differently? And who was involved in the representation of the parties? So I think that's where a good starting place, as Penny suggested.
Mm-hmm.
I would also ask mental health professionals. I think they have also watched people go through the process many times and have good information. Mm-hmm. That's about it.
Okay. Would the same thing be for lawyers, or?
I think that's a good starting point,
Mm-hmm.
to know people who've been involved in litigation and ask them what their experience was like, who they might suggest you contact. If you want to find out about a lawyer's professional standing, you can go to the website for the State Bar of California. All lawyers who are admitted to practice there, licensed to practice there, are listed. You can find out if they've had any disciplinary proceedings. You can find out if they have areas of specialization. You can find that out from the State Bar. If they're certified specialists in the field, whatever the field happens to be. In this case, we're talking about family law. The Santa Barbara County Bar Association has information that not only identifies attorneys who are practicing in the community, but also identifies their areas of interest or areas of emphasis. And so that's a way to get a start. But I think with regard to either the attorney or the mediator, I think it's incredibly important to recognize that when you have a consultation with them, you are making a decision about who you want to hire. And so I think the interaction that you have with that person is something that you have to place a lot of reliance on in terms of whether he or she gives you confidence that they know what they're doing, or you have a good personality relationship. There's a good feeling between the two of you that you can express yourself. You're not intimidated. They're open to questions. They're open to any comments, and then you make a decision. I certainly, unless the attorney you consult with or the mediator you consult with just scores 100, I think I would want to talk to more than one. I'd want to talk to 2 or 3 and get a good feeling of who do I want to have representing me in this very important process that I'm about to enter. And I think the personal and personality characteristics are extremely important.
I think as far as mediation, it's also, if it can be done for both parties, to be at the same initial consultation. It's an opportunity for them to see how the mediator interacts with both spouses.
I think that's a very good point.
And
Absolutely.
whether or not they can trust that person with that particular personality.
And so to set it up where the first time that they meet, that one doesn't first meet and then say, hey, you should go see this person, that they both meet so that they know that whatever is said, they hear, it's all said in the same room at the same time, which would really start that foundation of
Absolutely.
trust.
Very important.
Absolutely.
Okay, we have a short time left here, but I'm going to ask each of you, since you've both seen the ins and outs and the pros and cons, on a personal level, which would you rather see? To see a case resolved in mediation or court? Penny,
Well,
do you want to start or?
Well, I'm hopelessly biased for for mediation, and you know the driving factor for me mediating was the children, and how that can be handled in a private negotiation with the experts of the children, who know the children better than any expert that you could possibly have. And they take control of their family situation, and they step up and start to solve the problems. And I believe that mediation gives them a better opportunity to successfully get that done.
I've acquired the same bias over the years. I really feel there's so many disputes that go to court that really should be resolved by the parties. And we see this in the whole restorative process, the restorative justice process that's being used by community advocates to resolve disputes among neighbors and people who share property lines and all kinds of conflicts that can be resolved so much more effectively by the parties working out their differences rather than giving it to somebody else to decide.
Judge George Eskin and Penny Matheson, thank you so much for being here and to coming on the show. It's been great to talk with you, and I really have enjoyed it. What I do know, Penny, is that you are now retired, which is
too.
unfortunate for all of us.
Thank you. That's very kind.
But Judge George Eskin, you are now you are retired also, but you are now
I'm retired
starting.
from the bench. I'm not retired.
That's right. So tell us about what your new venture is.
Well, my new venture is a consulting service that includes mediation and conflict resolution and advocacy of various issues affecting the administration of justice. So that's how I'm keeping myself busy these days, and I thoroughly enjoy the process of helping people resolve their differences and come to mutual agreements in a variety of situations. However, I would not venture into the family law field.
Okay.
I think it's much too perilous.
Okay. And is there an email that they can contact you by? Should someone?
Sure. gskin55@gmail.com.
Okay. Thank you for the both of you. It's
Thanks
been a
for
pleasure.
having us.
Stay with me. I'll be right back with some closing remarks right after this break.
You are listening to Dr. Kim Taylor on KZSB AM 1290.
I hope that you heard some important information and that it can help you. I will say that the better you are at working together to make these kinds of decisions for your family, that the better off you will be in the long run. And also, it will help you to move forward with your own life and even emerge from this with a decent relationship with your ex. So if you've missed any part of this show, you can listen to the rebroadcast Thursday evenings at 10 p.m. and Sunday mornings 9 a.m. right here at KZSB AM 1290. You can also go to iTunes and listen to past shows. Just go to my website for the links at drkimtaylorshow.com. And of course, if you have questions for me, just go and email them at drkim@drkimtaylorshow.com. I'll be here next week live at 5 as I am every Thursday afternoon. And until then, remember, nobody else has to change in order for you to feel better. Take good care until next time. See you then.